or list of problems, I will say, well, what can you do for the small sat company? What are your thoughts? So that will be first part of the afternoon up to 15:40. Then there will be a break. Just an announcement to ensure that everybody will be there at 4 o'clock for the last part. There will be a photography. There will be a picture, as has been said by the organizer. So if you want to ensure to your boss or to anybody, your wife or whoever, that you were really there, please, during the symposium, please, and I will recall you, please be all there at 4 o'clock for the photo. So Niklas, the floor is yours.
Thank you. Thank you, Yvonne. Thank you very much. Yes, I will make a brief presentation on the international legal regime governing outer space activities, and in particular in relation to registration of space objects with the United Nations, with the Office for Outer Space Affairs. Before doing so, you recall the keynote address this morning by Mr. Kayode Shorgo. He already covered more or less the package that I will now try to go a little bit beneath and a little bit more detailed. And then after my presentation, of course, many of those perspectives and concepts will be addressed by Tanya Masood-Swan. But first of all, dear friends, this is a space station and nothing else. Now, as Kayode already pointed out this morning, of course, the treaty regime that we are applying in space law, in particular within the UN context of the COPUS, Committee on the Peaceful Uses of Outer Space, comprises the 5 UN treaties: the Outer Space Treaty, the Rescue Agreement, the Liability Convention, the Registration Convention, and the Moon Agreement. And then there is a set of principal and legal declarations also covering certain activities in space activities. Beyond that, we also have I would say, a number of soft law instruments in the form of General Assembly resolutions, which are identifying or interpreting certain provisions and behaviors in applying the legal regime. And we also have what I suppose you already know, the COPUS debris mitigation guidelines and the safety framework on nuclear power sources in outer space. I will not talk about those particular soft law instruments. I will concentrate on the main provisions of the treaties and then move straight into the registration regime. So, the first thing, of course, the most important paragraph or article in space law is Article 6 of the Outer Space Treaty on the international responsibility, which means that the launching state, or the states party to the Outer Space Treaty, and now we are talking, of course, about applicability and application of space law, meaning that the launching state, which is assuming functions and activities in outer space, bear international responsibility for its national space activities. And that includes governmental authorities and also non-governmental actors, which means that the private sector, commercial entities, non-governmental entities, institutes, academic universities, etc., they are also under this particular jurisdiction of the launching state. So international responsibility is very important to keep in mind. International liability, yes. The state that launches an object into outer space is internationally liable. And when you go down to the liability convention, a few lines down in this slide, you will see that we operate in space law with 2 concepts: absolute liability and fault liability. Absolute liability is absolute, yes indeed, in the launch phase, which means that if a damage is caused by a launcher or its space object that is being launched to an aircraft or to the ground of the Earth, then the launching state is absolutely liable for that, no question about it. It's different when there is a collision or a damage caused by a space object to another space object in orbit. Then it's based on fault liability, which means that we have to bring in the lawyers then to determine whose fault was it in the first instance. Now, with regard to the registration convention, you might already know what it is we're talking about here. What is the reason of registering space objects that are being launched into outer space? And what is the connection between the registration regime and the overarching responsibility and liability of launching states? there is a very interesting part of the convention, and this is quite rarely that the preamble of the convention really can give answers to what we're talking about here. But the registration convention, in fact, gives a lot of answers by reading already the preamble. And it makes the connection, a very clear connection to the Outer Space Treaty, the very fundamental provision of international responsibility. And moreover, and this is where many scholars have different views, but according to Outer Space Treaty, Article 8, and I will read it out, it says the following. A state party to the treaty on whose registry an object launched into outer space is carried shall retain jurisdiction and control over such object. Meaning that there is a clear connection between a national registry of satellites, of objects that that state has launched into outer space, and with the implementation of the registration requirements by registering objects with the United Nations. This is fundamental. Now, the registration convention itself, to date, we have 62 states parties. Well, you could say that's not that many, no, but if you look at the list here, you will see that the majority of the spacefaring nations, they are parties to the registration convention. And there are also, so far, 3 international intergovernmental organizations that have declared their acceptance of the rules of the convention, the obligations and rights of the convention. ESA, EUMETSAT, and EUTELSAT IGO. EUTELSAT actually made that declaration last year, so it's the most recent one. Now, some figures regarding the register. As I said, this Office for Outer Space Affairs, is maintaining the central register of the United Nations on objects launched into outer space. And we're doing this as under the delegated authority of the Secretary General. So all communications from states are to be made to the Secretary General and submitted to the Office for Outer Space Affairs. Now, in order to complicate things, of course, it's not that simple. We have 2 registers. Or rather, we have a register comprising of 2 different sets of documentation. Because the Registration Convention was established in the mid-70s. And the requirements that states are to submit, the data, the orbital parameters, the information that would be submitted under the convention, are being done under one series of documents if the state in question is a state party to the Registration Convention. Well, if you are not a state party to the convention, what do you do then? Well, no one can escape, if I say so, because in the early 60s there was a resolution established by the General Assembly opening up for this system of registration, which means that states that are not parties to the Registration Convention, they should submit registration information under that particular resolution. Consequently, another document series is used. And there is a lot of documents that have been generated over the years. I'm not going through all these figures because you can't even see the text, I suppose. But you're welcome to visit the website of the Office for Outer Space Affairs, and you will find the register there. It's a collection of the official documentation, the communication, that the submissions, the registration submissions made by launching state to the office. But we also make available what we call an online index. The online index is not the official register, but it is a research tool where we put down data and information on all the objects that have been registered with the United Nations, and also with objects that we know have been launched into orbit but that are not yet registered. So if you check on your state and you find a little red color or a green color on a certain object, be aware that it has not been registered. As I said, the main functions of the register establish a link between the launching state and a space object. And this goes back to Article 6, Article 7, and by all means Article 8 of the Outer Space Treaty. To serve as a central register of objects launched into outer space, yes, mandated to the Secretary General of the United Nations, and through delegated authority, it is maintained by the Office for Outer Space Affairs. To provide for states additional means and procedures to assist in the identification of space objects. And this is important because the registration regime we're talking about here is not a tool for space situational awareness. It does not provide the means for tracking of space objects. It is a main tool to identify what is up there, what has been registered, and you can identify the orbit. It's mainly to identify the orbit, but you cannot get information where in that orbit a given object is at a given time. But it is more a tool to establish the genuine link, if I say so, between the object and between its launching state. Now, we are producing right now a handout, as was requested by the legal subcommittee of COOPUS last year, and we will have it ready for the upcoming session of the legal subcommittee. It's a handout to be provided by OOSA and with ITU, and where we will address registration, authorization, space debris mitigation, frequency management for the benefit of space actors intending to operate small and very small satellites. So it's clearly targeting the community operating small and very small satellites. And in terms of the registration, the following messages are quite important. And of course, there will be a lot more text in this handout, but only one state of register should exist for a particular satellite. We don't want to operate with dual registration. We have such cases, but it should be one state. So if there are more than one launching state involved in a single launch of an object, they should make up who is the state of register. Only registration information provided by diplomatic missions accredited to the United Nations will be considered valid. We cannot accept registration submissions from private companies, from universities, from authorizations. It has to be diplomatic missions of states. And registration information provided directly by national agencies will consequently not be accepted. Now, if we turn to a little bit of, I would say, de lege ferenda, the types of information and space object registration form. These are two things that I will now concentrate on, and then I've done my presentation. First of all, the Registration Convention Article 4 provides the basic information that should be submitted and covered by registration submissions, and that is to define the orbital parameters of that object that is being launched into outer space, plus the identification of the object itself. Now, there is a resolution by the General Assembly, Resolution 62-101, that provides additional information, gives the means to launching states to provide additional information that could be of interest in enhancing the practice, the common practice of registering objects launched into outer space. For instance, who is the owner of a space object? Who is the owner of the satellite? Who is operating the satellite? Is there any change in status of that satellite? Has the ownership or the control, the jurisdiction of the satellite changed while in orbit? And those are information that are not covered by the Registration Convention, but that has been included in this General Assembly resolution that is also used to determine the information that is desirable. So, coming back again to Resolution 62-101, you will see on this slide, it's a snapshot of the information that additionally and voluntarily, of course, could be submitted to a registration submission. Harmonization of practices in terms of what units are you using, the times for you are using. GSO location, it's not covered by the convention itself, but this is something that came through this resolution. Determination of the state of registry. Remember what I said, that we really try to have one state of registry. It should not be that several launching states, that one of the four qualifying launching states should register, should not be a dual, should be only one state of registry. When there is a separate registration in case of joint launches, when there is a joint launch, one state is providing the launching of a satellite that belongs to another state, where the practice is that there is a separate registration being submitted. The launch service provided should advise owners or operators to address the appropriate state on the registration, because it has to be in the entire chain that the registration requirement is kept in mind already in the planning phase of a launch. and also providing information on date of change in supervision, the identification of the new owner or operator, and this is very important if there is a transfer of ownership